Welcome, everyone. I'm thrilled to see this room is filled with members of the judiciary, my fellow colleagues of the Rhode Island Bar, and of course, our gracious hosts at Roger Williams Law School. Everyone has braved the cold and the bridge traffic to come together in person to honor Judge Smith in recognition of his taking senior status last month. My name is Stephanie Friedel. I've been a litigator in Rhode Island for about a decade. I'm also the chair of the Young Professionals Committee of the Rhode Island Division of the Federal Bar Association, a title that I am barely clinging to considering my years in practice. In any event, when the FBA board met several months ago with the goal of planning an event to celebrate Judge Smith and the profound impact that he has had on the federal bar and on our Rhode Island legal community, it was clear to all of us that the ideal audience for Judge Smith's words of wisdom would be the youth of our profession, students, young lawyers, or those starting out on a new path within our profession. Judge Smith has been a role model and a mentor to so many among us. It was equally clear that a setting here at the law school where Judge Smith has both taught and served as chair of the board would be the ideal forum to honor him. Judge Smith has dedicated his life to public service. A portion of these efforts have been centered on our own legal community, fostering connections between the bench and organizations like the FBA and the law school. Judge Smith was instrumental in establishing and cultivating career-invigorating programs such as the Litigation Academy in recognition of the need to provide real courtroom experience to the next generation of lawyers. While I'm up here, I would like to make a quick plug for membership at the Federal Bar Association. Membership for law students is free. We're also looking for a law student to join our FBA board. Please reach out to me either in person or via LinkedIn if you are interested. We put on programs like these, and we also plan to host another event in the spring featuring Judge McElroy and Judge Montecalvo. As I believe Judge Smith might touch upon today, participation in organizations like the FBA and the Rhode Island Bar Association can help you make meaningful connections that can animate your entire career. With that, I'm going to turn it over to our Masters of Ceremony for today, known to everyone here, Professor Yelnosky.
Thank you. Thanks, Stephanie, and thanks to the FBA for getting us together. Before we start to chat a little bit, I thought I'd say a couple of words about Judge Smith, perhaps for some of you who are not familiar with him. But for those of you who are, I think you'll understand why it's difficult to describe succinctly what makes him special and what makes his career worth celebrating. He contains multitudes, I would say. He's been a well-respected federal trial judge since 2002 because he's scrupulously fair and ethical. He's even-keeled. He's hardworking and smart and curious. He's innovative, and he treats with the utmost respect all who appear before him and with whom he works. He has been a generous mentor and friend to many, and he has lent his considerable talents to individuals and organizations that are better for his contributions, including, quite notably, this law school, our law school. And notwithstanding his swamp Yankee countenance, I would describe him as young at heart. He has a soft spot for puppies and children and law clerks. He likes to ride his bike, to play squash and tennis, to ski, and to hike. He's a fallen Democrat and a member of the endangered species that is the moderate Republican. And he's very funny and is often looking for opportunities to be funny and to have fun. And it's my honor to be in conversation with him today and to welcome him to today's festivities.
Well, working with you provides a lot of opportunity for humor. I'll just say that.
So let's start with the present. You took senior status effective January 1st of this year. And I thought it might be helpful for people to hear what it means to be a senior judge in the federal system. What will your professional life look like? And maybe talk to us a little bit about why you chose to go senior when you
Sure.
did.
Well, being a senior judge in the federal system is, it's really one of the great privileges of the federal judicial system, is the ability to kind of continue on in this work, but to be able to sort of choose your own adventure. I mean, it is true that you work for free, but they do give you, law clerks in a nice office, and you can kind of make some decisions about what kind of docket you want to keep, and so what I am doing, everyone does it differently. Some judges just keep on going as if they're a regular full-time judge. Others do very little, and some are kind of in the middle, and I put myself sort of in that middle category. I've decided to take just a civil docket, not a criminal docket, and I've eliminated certain types of cases that so that I can just focus on other types of cases. And then I have a bunch of matters that I've hung on to that I need to finish. I need to finish working on, and I'm just trying to figure out, what I want to do in the long term. Do I want to stay with it and keep going, or maybe fully retire and do something else? But the judiciary relies very heavily on senior judges all around the country. Senior judges feel a big capacity need of the judiciary, and the judiciary is really indebted to senior judges who carry these loads that when they could easily just retire and not do any of it. But so that's what it is.
And how about timing? Why now?
Why I take senior status when
Yeah.
I did? Well, my intention in announcing that I was going to take senior status very early, and I did it 18 months in advance, was to create the vacancy. The way our system works is that once you say you're going to take senior status, that creates the vacancy and enables the process to start working. And I wanted to give the senators an adequate amount of time to do their due diligence and decide who they wanted to suggest to the White House as a replacement. And understanding that political considerations and other kinds of things can delay nominations, I wanted to give them a big window to do that. And one of the reasons for that was that twice during my 23 years, a vacancy occurred, and then a nomination was made and then held up for many, many years. Judge McConnell's nomination took 3 years, I think. Judge McElroy's took 3 to 4. So when that happened, we went from a 3-judge court to a 2-judge court. And that's a big deal when you take away 30%, 33% of the capacity of the court. I didn't want to see that happen. It happened twice on my watch, and I didn't want to see that happen a third time. I was also cognizant of the fact that I felt that it would be more likely that we would get a smooth nominee, and it would go well with the 2 Democratic senators and a Democratic president. And I thought, to avoid any really bad situations, which could happen, where someone gets nominated and then the senators don't go along and you have a vacancy that goes on for 4 years, and those kinds of things happen. I wanted to avoid all that, and it worked. It really worked really well.
So while we're on that subject, and I know that the federal judicial selection system is different depending upon the level of court, but could you give us your impression of federal judicial selection? What's going right? What might not be going so right?
Sure. Well, the federal system for judicial selection is not uniform. It's all over the map. Some senators use selection committees to help them pick a nominee. Others guard the privilege that senators have to come up with a nominee very closely. That's the way our senators are, particularly Jack Reed. That's the way he feels about it. And he works closely with Senator Whitehouse to come up with nominees. And there are all sorts of in between where you have senators from different parties, and it depends on if the senators are of a different party than the president actually does the nominating, the senators do the suggesting to the president. So it's kind of all over the map, but my feeling is it works really well, even though it's not uniform, and it works well for, I think, a bunch of different reasons. There's a lot of vetting of nominees that happens. You know, it's not as if you can just pick anybody and throw them out there and they'll become a judge. You know, you get vetted by the American Bar Association and by the White House and by the Justice Department and by the Senate Judiciary Committee and the FBI. So there's a lot of digging and vetting that goes on. So that works pretty well. And I think that overall the senators and presidents have taken the responsibility of nominating qualified people for the judiciary very seriously. So, you just get a whole different kind of very diverse, I'll say, group of people who become federal judges all over the country. And they don't all go through the same pipeline. They don't have identical experiences. They have lots of different kinds of backgrounds. So if you have a case in Rhode Island or in Maine, it might be very different kind of judiciary than you get in Kentucky or in Arizona. But it's all together. It's a really good group of judges. Now there are differences. Different presidents prioritize different things. One of the things I've done a lot during my career is help train new judges. So when you go off and do a training for, we call them baby judges or baby judge school. You go to do a baby judge school of judges who were appointed by Obama. That group of judges looks very different than a group of judges appointed by President Trump. But overall, those judges are all competent and all capable. They have different backgrounds. Their profile is different. Now, it's not 100%. There are some, there might be some anomalies out there, but overall, the judges, while they come from all kinds of different backgrounds, are, I think, highly competent, very capable, and I would say that diversity of different kinds of backgrounds and strengths and weaknesses is actually one of the things that makes the federal judiciary so strong. You have some people who are public defenders, you have other people who are prosecutors, you have others who are civil lawyers in one kind of civil practice or another, but they work all together and they get to know each other and they rely on each other. So I think that's one of our strengths, is that we're not a kind of cookie cutter institution where everybody sort of comes from the same background.
So let's talk about your particular path. I know you're from Boise, and your father was a judge. You arrived here in 1987 after graduating from from Georgetown Law School. And 20 years later, you're here in a place you had never been before. So, when did you decide you were interested, and what steps did you take to try to, if any, improve your chances at this brass ring, which is it's very, if one's set out to be a federal district judge, your chances of achieving that, strikes me, are pretty slim.
Right.
How did you
Yeah.
get there?
Okay. Well, I mean, just, to be perfectly blunt and honest about it, it's as
Please.
much as we might like to tell ourselves a different story, it's 90% luck and 10%, everything else. I mean, you just got to be, at the right place at the right time, and the circumstances have to break, just perfectly, and and I got lucky. I mean, that's really what it comes down to. Now, in terms of when did I think that I might want to do this, I've always had it in the back of my mind growing up. I mean, my father was a judge. All my siblings are lawyers. I mean, we just grew up in this environment. So I, kind of had it in my mind that I'd like to do that if I had the opportunity. In terms of coming up with, how did I put myself in a position where that might happen? Well, you know, I tried to develop a practice that was one that was intellectually challenging, where I could develop my skills as a lawyer. I could learn enough about trying cases, even though I didn't try much in court, but enough that I could, be able to reasonably claim that I knew how to try a case. And I made public service and public part of law part of my practice, which put me into contact with people who were in politics, and I did that not just with the goal of becoming a judge in mind, but more because I just liked it. It was a more interesting kind of practice to me. A lot of things about working in a big law firm like Edwards and Angel were pretty dry and not quite as interesting. But working in the public sector got you involved in all sorts of interesting kinds of things. So I ended up, representing the governor and the Secretary of State, and represented the Chief Justice in a labor issue that they had, and I ended up being the city solicitor in Warwick, and that brought me into contact, with Lincoln Chafee, and he became a senator. And you know what they say about, well, what's a state court judge? Friend of a governor. What's a federal court? Who's a federal court judge? Who's a friend of a senator? So it helps to get to know the people who are in the position where they can appoint you to these, or nominate or suggest you for nomination for these positions. So I made public service a big part of my practice, and I think that was really integral to ending up in the right place at the right time. And the other thing I did, frankly, was just, there came a point in time where it's a kind of a long story, but the short of it is that John Chafee had died. John Chafee, long-serving senator from Rhode Island, had died, and Lincoln was appointed to take his place.
His son,
who was the mayor of Warwick, and there, it was pretty clear that there was need for somebody who could kind of take charge of that situation, and so I had the opportunity to do that. So I left my law practice and did that for a year, and I ran the Senate office for a year, and that was a pretty crazy thing to do, and was not the most immediately well-received idea at home. just the pay cut at first, the six-figure pay cut was a bit of something to swallow, as the kids were sort of in private school, or Catholic, LaSalle and all that, heading into college. And so there was a little bit of convincing to be done with that. But, it did occur to me that, well, at some point, a federal judgeship might open up, and, I'm not going to get the federal judgeship unless I know the senator, and he's the senator, and, and unless he gets elected, that's not going to happen. So figured I would just do it. I ran the office and I ran the campaign, and he won an election that nobody thought he would win. And, and then I went back into practice, and sure enough, Judge Laguerre took senior status, and the position opened up, and there was the opportunity. But there was one thing that stood in the way, and that was you needed a Republican president. And so, even though it wasn't the most popular decision in other quarters, in my house, Bush versus Gore was a very popular opinion. Because without that, we wouldn't have had a Republican president who relied on a Republican senator to make a suggestion about who should fill that spot. So, when I say 90% luck, I may be a little understating it.
Yeah, because not to bring up a sore subject, but to emphasize the luck associated with getting these kinds of positions, it was only a few years later that the politics broke in the wrong way, and your nomination by that same president to the First Circuit died before the Senate.
Right. And and that had its own sort of interesting dynamic with the two senators who, you're in Rhode Island, these people are people. I mean, we practice together. I mean, but politics comes first, and they shut down my nomination to the circuit. And but at the end of the day, life is funny. I mean, things work out. I mean, it was a really, they did me a huge favor by blocking my nomination to the First Circuit. When we're all really good over it all, and when I became chief judge of the district court, things were still a little tense. So I went down to Washington, and I had a private meeting with both of them, and I went in and I said, look, we've had some rough times, but in the interest of the court, why don't we just totally bury the hatchet? I got no hard feelings. And they're like, okay, that's a good idea. We've been best friends ever since. So. And I'll tell you, when I say, and you're going to get into the chief judge thing and all of that, but one other thing I would say about that is if I had gotten nominated, if I had been confirmed to the circuit court, I'd be chief judge of the First Circuit right now, and it wouldn't be David Barron. And I've been doing a lot of stuff with David Barron because we serve on the Judicial Council of the United States, which is the governing body of the courts together, and we're doing some other special projects together. And I said to him not too long ago, we were in a meeting of some sort, I said, and this came up actually, I said, I'm really glad that I didn't become a circuit judge and the chief judge, because you're so much better of a chief judge of the circuit than I am. And I wasn't blowing smoke. I mean, he's a really good chief judge of the circuit, and he's about 10 or more years younger than I am, and he's just doing a fabulous job as the chief judge of the circuit. And I think I think it was really good because he's very innovative and he's full of energy. And you don't want somebody becoming a chief judge, in my opinion, the chief judge of a circuit court at kind of the very tail end of their career. It's really better that you get that job right in that sweet spot of just enough experience he knows what he's doing, but he's still got a lot of innovation and energy and so forth. So it was really a good thing, and for other reasons more than that, but that was one reason.
Well, let's talk about the chief judge piece, just because we're there. When you think about the job of being a federal district judge, you're a trial judge, you're handling cases, and we'll talk about that in a moment. But one thing that maybe judges don't think about, and certainly lawyers and lay people don't talk about, the administrative aspect of these courts. And every 6-7 years, the leadership of the court rotates, and you're in a position where you've got to flex some muscles, let's say, that are different from those that you flex when you're handling cases. So how did you view that role? I assume some people really dislike it. It's just a pain in the butt.
Yeah.
But you have really been lauded for many of the innovations that you brought to the district court. And I'm curious about how you viewed that role and what you tried to accomplish.
Yeah. Well, we're really lucky because being the chief judge in a district like Rhode Island doesn't carry an enormous amount of administrative responsibilities. It does carry some, but you're so well supported by such a great clerk's office. Nora, our clerk of court, is here. Nora Tyre-Wittick. And they take the most of that responsibility off your shoulders. But there definitely is some, and some of it can be really important. But you definitely set the tone for the leadership of the court. And then I felt there's real opportunity to make some significant changes in the court, and so I kind of relished the opportunity to do a lot of that. And I just happened to become chief judge at the time when there was a lot of opportunity to do that. So again, that's kind of right place at the right time. But we hired Nora, a new clerk, a very important hire, because she was able to really set the tone for the clerk's office and change the dynamic in the clerk's office from sort of the way, very traditional way it always been done, to sort of new leadership thinking that she derived from her time in the military. So that was terrific. We hired a new chief probation officer who was able to really change the dynamic significantly in the probation office. And then there were just, it was really kind of low-hanging fruit in a way. There are just so many things that we were able to do, to try and do things differently. So on the sentencing side, there was a lot of attention. I became chief judge a little over 12 years ago, 2013, I think it was. A lot of tension at that time with reentry courts. And Judge Sullivan had gone, off and learned about reentry courts, and Judge Connell and I had done the same at some district court conferences, and we all sort of saw this opportunity, and she wanted to take that responsibility on, and so we ended up with the Hope Court, and that's now 10 years old, hugely successful program. Judge McConnell and I, brainstorming one day, thought we should put together some kind of a youthful offender program, so we created this deferred sentencing court and a program. Again, I think quite successful, in some cases not successful, but mostly successful. the media I have friends in the media, they'd always complained about the way federal court treated folks in the media. Um, so I brought all the people that covered the court to the courthouse and said, what would you like to do? You know, and they, oh, can we tweet from the court? Can we use our laptops? I said, sure, we can do that, but you have to police yourselves and you have to make sure it doesn't become a problem. They embraced that role, and so we opened the court up to coverage by the media, and then I got thinking about trial skills, and that led to the Litigation Academy, and actually there was a real deep connection to the law school that led to the Litigation Academy. At that time, I was teaching a course here on complex litigation that was a year-long capstone type course that mimicked a complex case that worked its way from the filing of a complaint to a trial. It was a very labor-intensive course, but it was really, I think, still have students who were in that class come up and say that was the best course I took in law school, and so I thought we could do that in the court, and so I got Brooks and I got Nikki Kukas and Brooks Magratten, and we brainstormed and got a group of lawyers together, and so many of whom are here, and we created the Litigation Academy, and we got judges involved, both the federal court judges and state court judges, and we did that in a partnership with the FBA and the law school, and now that's 10 years old, and literally hundreds and hundreds of students have been through the Litigation Academy, and all these great lawyers who are here, Mark DeSisto, and I see John Foley, and Matt Oliverio, and many others have all participated in that as faculty, as well as the federal court judges, state court judges, and it's just been great. Now, if I
Actors and actresses from Trinity.
and that was Brooks's idea, not mine. I mean, that you got to give credit where credit's due. He just wanted to make friends with the actors at all the theaters he goes to, so he got them, in, and I mean, and that has been a fabulous thing. So, it's just turning the court into an institution that does a little bit more than the traditional function. That doesn't just receive and process cases, but is more proactive as a place that helps train lawyers, and that was the idea, and it's been great.
So we're approaching the end of our time. I'm just got two or three questions I want to cover. One is about your time handling cases, and you and I have talked about this a little bit. It's an obvious aspect of what is happening and has been happening in federal trial courts for a while, and that is the demise of the civil trial, the vanishing trial. I think the data now show less than 1% on the civil side, and that includes bench trials, so jury trials are quite rare. What impact has that had, not just on your work and the work of your colleagues in the future, but just in terms of thinking about dispute resolution? Do you view this as a negative, a positive, somewhere in between?
Well, I think there are negative and positive aspects to it. I mean, in terms of my own work life, it used to be, in the first 10 years, maybe even 15 years on the court, that I could count on trying 4 to 5 jury trials a year, and maybe a couple of bench trials. I think over the course of my career, I've had, I think 130 trials. I think 80 or 90 have been jury trials. The rest have been bench trials. So, the numbers kind of work out. I mean, that's some years more, some years less. The last few years, it's really hard to get a jury trial. I mean, there were a couple during COVID. I just had one not too long ago, but it had been a couple years since the last one. So we just don't have that many. And so, is that a good or bad thing? Well, from my point of view, it makes the job a little less interesting because the trial part of the job was one of the best things about it. And so in a lot of ways, I feel like I've become much more of a case manager and make decisions, write opinions, summary judgment motions. And, I've learned by this time that, the parties care about what you write in those opinions, but the Court of Appeals definitely doesn't care. And so, so that gets you kind of, I like writing opinions, but it's, you sometimes wonder if that's, but people become trial judges because they like to try cases, and we just don't try that many cases. So in a lot of ways, the job becomes much more of almost like a case manager. You're just managing, a few hundred cases that are civil cases that are working through the pipeline. You're helping people resolve their discovery disputes, and then you're, maybe deciding a motion at the end. And so where the action is, honestly, in the judicial side of things, to me, is in mediation. I mean, that's the magistrate judges have known this for years, and they didn't tell us that was the really fun part of the job. They've been hiding that for all these years, but that's really where the action is now in federal court, I think. And is it good or bad for the litigants? I mean, the market is deciding. The market's deciding that trials are not how they want. People just don't want to resolve their disputes in trials. So what does that mean? Well, I think it means mediation is much more prevalent. I think it means that litigators need to focus, and I had this conversation with Mark DeSisto the other night. Litigators need to focus much less on, I want to be a trial lawyer than I want to be a lawyer that knows how to manage a case to the point where it's going to get resolved. Cases are going to get resolved, generally speaking, in one of two places. They're either going to get resolved on the law at a summary judgment motion, or more likely they're going to be settled. Only, as you said, less than 1% are going to go to trial. So litigators need to think about, how do I take that case from the point where it comes in the door to get it to the point where it's going to resolve favorably in some fashion to my client. How do you do that? It's about assessing the case. It's about knowing how to do discovery. It's about knowing how to conduct a deposition. It's about getting your record created so that you can have an effective either summary judgment motion or mediation. And I just think it is what it is. I mean, I'm not going to sit here and cry crocodile tears over the demise of the trial. I just think it is, the system is evolving, and that's just the way it is. If you go to law school these days, you got to understand that's what it is, and be willing to work with that. Doesn't mean you'll never try a case, but it's not where all the action is going to be.
So, as we're all sitting here today, the government of which you are a part is experiencing what I would describe, at least as in my lifetime, an unprecedented pressure testing. And your colleagues on the district court across the country and here have been on the front lines of this first volley of sort of checks and balances between the executive branch and the judiciary. And I'm wondering if you feel comfortable talking to us a little bit about how you see this struggle, how you would describe it, what you think is at stake, and talk to us a little bit about the role you see for the courts today.
Well, it absolutely is unprecedented. There's no question about that. I was doing some research for another talk recently. I was looking into the issue of nationwide injunctions. In the Bush administration, George W. Bush administration, 6 nationwide injunctions were issued in the entire 4 years. During Obama, there were 12. Biden had 23. In the first Trump administration, there were 64. And just in the first month of Trump 2.0, I think there have been 75 injunctions in the first month. Now, not all of those nationwide, most of them have. So we've entered this sort of new era where we're doing government by executive order and nationwide injunction by the courts. And Congress has just been completely cut out of the system. So it's not the way our Constitution envisioned the making of law and policy in the country. So in its most benign form of what's going on right now, you could say, well, this is just not the way the system is supposed to function, and there are dangers associated with trying to govern by executive order and injunction. In the first Trump administration, the win rate on those cases was about 22%. So even if the win rate in this administration is 20 to 30%, you can kind of think, well, their vision may be that, okay, we can never get all that much legislation through Congress. We'll take a 20% win rate. But this is not the way the system is supposed to function. And that's in the most, as I said, the most benign way of looking at what's going on. I don't think it's fair to assume that, my view is the judiciary is doing an extraordinary job of managing this onslaught of litigation associated with these executive orders. But we shouldn't assume that the capacity, as you put it, pressure testing, the capacity of the judiciary to manage this is just unlimited. It is. It really. I don't know where the breaking point is, but it's not the way the system was designed, and that's putting aside the question that we were hearing a lot of talk about now about whether the administration would defy an order of a court, a lower court or the Supreme Court, and that's just a whole nother kettle of fish, and that of course is not contemplated. We've never been there before. I don't have any reason to believe, in spite of all the things that have been said, I don't believe this administration would do that. But that's really dangerous territory. This stuff puts a lot of stress on our judges and our courts. I mean, the number of phone calls, emails, that sort of thing that are flowing into the courthouse right now because Judge McConnell is dealing with one of the impoundment cases. There are people in the clerk's office and marshal's service that have to read all these things, and they have to listen to all these things, and you can't believe the things that people write and say. And it's it's a real ugly side of our country, fortunately. It's not going to change any outcomes. It just is something we have to deal with. But it's it's tough. It's and some courts, like the District of Columbia District Court, I mean, they're just getting buried in these cases. So, but my view, the judiciary is responding remarkably well, and I think I know I'm biased, but I think they're doing great.
Thanks. So we've got a few minutes for audience questions. There are microphones at the end or beginning of each aisle if anyone is interested. Tom.
What would you do differently, if anything?
Okay. Well, you learn as you go. I mean, there's a lot of things that I do differently. I mean, one thing that I got a lot of credit for was taking kind of a aggressive stand back in the days of the crack powder disparity issue. But I look back on what I did there, and I think, why didn't I have the courage to, without getting in boring details, but the ratio was 100 to 1. I said, no, we're going to do 20 to 1. And I think, why didn't I just say they were the same thing? They were the same thing. I mean, but you can only see that in hindsight, with hindsight. I mean, because the environment was such that what I did was, in some quarters, thought pretty radical. But to me, now looking back, it was insufficient. I would have done that differently. One thing I've been doing in the last maybe 4 or 5 years or so is meeting with all the defendants that I've had as they come out of prison and spending time with them and getting to know them and encouraging them. And some come back, some come frequently. And I don't know, I picked that up somewhere along the way, and I wish, I say to myself, why didn't you start doing that, 20 years ago? I wish I had done that. So there's a lot of things like that I wished I had used more text orders instead of writing so many opinions.
Think of the time that would have.
I mean, all the time. There's so much can be done by text order. I've come to love the text order. So anyway, there's 3.
Anybody else?
Come on, I know there's more. Peter.
What observations, not necessarily just with respect to civility, but what observations have you made about how or whether lawyers have changed from when you started in 2002?
Yeah.
Observations about the behavior and practice of lawyers over the time you've been on the bench.
I not major changes other than I think we're much more sensitive nowadays to it's less. I mean, how do I put this? It's less it's less of an old boys network, I guess. It's a more diverse bar. It's I think there's a lot more mutual respect in all directions. We're just so lucky in Rhode Island, and we always have been, that we have such a collegial bar, particularly in the federal court. I mean, we're just really lucky. And and I think that was the case, has always been the case, but I think it's even more so now. I do think that younger lawyers have more of a challenge because they just have fewer opportunities to appear in court. And so it's a little more difficult to be in court and to sort of get your sea legs. But I think most judges are sensitive to that and want to help the younger lawyers learn those ropes. So, but overall, I think the quality, and again, we're kind of a self-selecting group, and the only people want to practice in federal court who want to practice at that level. So there is that.
Yes, Ruth.
Do you think that as a judge that judges in general have more opportunities to progress the legal system compared to attorneys?
I didn't hear the end. More opportunity to.
To progress the legal system, make systematic changes in the legal profession as compared to attorneys.
Well, we do have some opportunities, but Michael and I taught a course once on law and social change. Remember, and that was the sort of the topic. Judges are, we're the passive part. We take what comes. So it's the lawyers that are out there developing the cases and thinking of the legal theories and bringing them to court. So I would say it's both in equal measure.
Thanks, Jared. You get the last one, I think. Well, no. Go ahead, Jared. And then...
Denied, Jared.
By the way,
Whatever it is you want.
by the way, guess
Denied.
which opted out of since he...
I am, but I'm curious to hear what it's been like for you to be involved in the growth of this law school and the development of the law school, and also what you think law schools can be doing to help, further, the cause of justice and law.
Did you plant that, or did you steal your?
It was on the list.
It was on the list.
Yeah.
Well, it's the relationship I've had with the law school has been just wonderful over all these years, and I've mentioned this many times in the past when the idea first came up to have a law school in Rhode Island. I mean, there was a lot of opposition in the bar, and some of it was in my law firm, and I was only a fifth year associate or something at that time, and the thought was that that this would diminish the quality of the bar, that it would push out into the system more lawyers who weren't going to practice at the highest level, that kind of thing. That was and too many lawyers. We just and I just think that thinking was all wrong. And I think over the years the law school has really proven that it's elevated the practice of law in the state, and it's been I think just a great thing for the bar, for the judiciary, for the whole community to have this law school as part of it, and just in terms of my own relationship with the law school, it's just been great. I mean, teaching. I mean, there were some years when I don't know. I can't really explain why I did what I did, but there was a time when I was teaching 3 courses here. I think I was teaching a full load, and it was absolutely
More than full load.
It was crazy, and the the judicial process seminar that I taught with Justice Flaherty for many years. I mean, that I did for 15 years. I mean, it's been great, and one of the greatest things about it, the relationship, is just I've hired many law clerks from the law school. I've had dozens and dozens of externs and interns over the years, and to see all those people grow in their careers and thrive in the community. I mean, I've had court proceedings where every attorney in the courtroom was either a law clerk or an intern in my office. I mean, that's amazing, and really, really cool, And so it's been one of the most rewarding parts of my my career, is the relationship with the law school, and and I think that I would just maybe close on this. I mean, what we're seeing happen out in the world right now, in the country, I mean, it's a great time to be a lawyer. This is these are the times that call on lawyers to to live up to their the aspirations of our profession, and you're just seeing it happen every day. What's happening in the Justice Department is a good example of that. So, it's scary times, but inspiring times. And I don't think there's ever been a better time to have a law school that is dedicated as this one is to public service. So, there you go.
Well done, Jared. Well done, Jared. So before we break for refreshments, I would like to welcome Dean Bowman to the podium. And Brooks, you're on deck, I think.
Thank you, Dean Yelnosky. Judge Smith, I'm glad you're here today, and I'm honored to be part of this as well. So, lawyers are storytellers at heart. So I'm going to tell everyone a very brief story about a man named Smith and a man named Bowman. My story starts in 2020 when I arrived in Rhode Island during the depth of the early days of the COVID pandemic to be our law school's new dean. I did not know anyone in Rhode Island. Well, I knew Michael Donnelly Boylan, who's our associate dean for strategy and enrollment, but he technically is not from Rhode Island because he lives in Boston. So back to my point, I knew no one. I had not even visited Bristol before I took the job. My on-campus interview tour consisted of Jared and an iPhone on Zoom going, and here's the courtroom, and here's Dean Yelnosky, say hi. So I had not been here. And the university and law school were in the middle of a budget crisis. And, as you may remember, as I just said, it was the dark days of COVID-19. So my timing was positively awful. Looking back on it, I really have to question my judgment. But I was really fortunate to use Judge Smith's word lucky in one way at least, and that was that Judge Smith was the chair of the School of Law's board of directors. And that, as they say, made all the difference. I could always call on Judge Smith for guidance and advice, which I did often. I could count on him to give me the historical context on anything I needed to understand it more fully, which anyone from Rhode Island knows is absolutely essential to understanding anything in Rhode Island. And I could always rely on his judgment. So, Your Honor, Judge Smith, for your guidance and counsel, for your steady and even temperament, for your humor, for your commitment and support for the law school, for helping the new guy, that's me, in 2020 find his footing during a very challenging first year on the job. And for so much more, I salute you and I thank you from the bottom of my heart. And as they say on TV, but wait, there's more. Chantal Bromage could not be here today. One of Judge Smith's former law clerks unexpectedly could not be here, but she did provide us with the following remarks for us to read on her behalf. So, dear Judge Smith, I am so disappointed that I am not able to be a part of this celebration of your career on the bench in person and to hear your many words of wisdom as you reflect on your years as a judge, especially after I found out that RWU was going to let me make some remarks. But I am grateful for the suggestion that I submit a message to you anyway. You have profoundly impacted the education and careers of so many RWU Law alums, including myself. I am one of the few students who didn't roll through your judicial externship class, but in spring of 2013, I did have the privilege of taking the judicial policy seminar you used to co-teach with Michael Yelnosky. With only a handful of students in that class, I enjoyed the opportunity to witness the two of you bat ideas and theories around about the impact of various important Supreme Court opinions, with the occasional opportunity for student input into those conversations.
That was a mistake.
I'm kidding, of course. But as a student, I never thought my own thoughts would be as valuable or as interesting as what the two of you discussed. Without a doubt, this seminar was one of the best courses I took during law school. Fast forward a few years to the annual Roger Williams University Law Alumni Holiday Party, where I had the chance to talk with you for a few minutes and left with an invitation to submit a clerkship application to you. I learned a lesson that day that I frequently pass on to students and judicial externs. Go to events in person, because you never know what conversations you'll have, or with whom, and what opportunities might come out of them. Your subsequent offer to clerk with you starting in 2016 led to more clerkship opportunities than I had thought possible, and indeed apparently to a career of serving as a law clerk. There is no doubt that my legal career has unfolded in the way it has because of the opportunity you gave me to clerk at the Federal District Court. My year working for you taught me so much about the litigation and prosecutorial processes. I learned that while the basic steps of each case may be set by the rules of procedure and governed by law, the presiding judge's approach to each contact with the parties, whether through resolving the formal motions filed or holding chambers conferences, can have a profound impact on the ultimate resolution of each case, as well as the parties' experience with and overall feelings about the judiciary and justice system. I watched in awe more than once at how closely you listened to the parties and crafted next steps or resolutions that were thorough and fair and often quite creative. One of the many lessons I took with me from your chambers is that no matter how busy we are, it is so important to take the time necessary to consider not only the correct legal outcome for each motion or point of contact with the parties, but also how that outcome is going to impact later stages of the case and whether there are any alternative outcomes that might make more common sense at that juncture. I'm thrilled that I am now working down the hall from your chambers and hope that you will be sticking around for a while to enjoy having new neighbors on the second floor. I wish you all the best as you explore the options available to you in your new senior status position. Chantal Bromage, Esquire, Roger Williams University, class of 2003. Now I'm going to turn over the podium to Brooks Magratten, but also we have something to present to you. Is that a check? For you.
Thank you.
Stand in front of you, Michael.
That's great. Thanks very much.
There you go. Thank you.
That's great.
All right, Brooks, you're up.
Sit down again.
How you doing?
Brooks.
So in order to really appreciate Judge Smith's impact on the bar, you really have to go back in time. And I want to talk about the relationship between our federal court and the bar in the 1980s. It was a different relationship than today. And, you know, Tom and Matt and Mark and everyone here with graying hair or no hair talking about. But the relationship was a bit frosty. But there was a thaw, really started in the 1990s. Judge Torres got together a big group of attorneys to overhaul local rules. Judge Lisi opened up the courthouse for public lectures and public tours, which was great. But the big thaw came when Judge Smith arrived, and he really opened the doors of the courthouse for all to see. A litigation academy, which has been, a wonderful program, and he talked a little bit about that initial meeting to get it off the ground. And it was Judge Smith and Nikki Koukas and me. And Judge Smith has this wonderful gift. I mean, he can just look you in the eye, immediately size up your strengths and weaknesses. So he looked, I'll never forget this, he looked at Nikki straight in the eye and saw immediately that she's just a highly intelligent person. And he said to Nikki, I want you to develop the curriculum, find the faculty, develop trial materials, get the LE. And then he looked at me and he said, bring the donuts. And that's pretty much been the demarcation of how Litigation Academy has worked for the last 12 years. We've done 20 programs. Nikki's been fabulous, really, in developing the program and working so hard on it. And I've kept Dunkin' Donuts going strong the whole time. The great thing about Litigation Academy, though, is not just for students. I mean, it's Judge Smith's way of bringing the whole bar into the courthouse. And we've been so fortunate with this bar of having so many senior lawyers who are more than willing to donate their time to come in to give lectures, to help with critiques, to do any kind of teaching. And it really has been a community project. I'm not aware of any other district really that has a program quite like this, with a wonderful partnership of the law school, the FBA, the federal court, and actors from Broadway and from Hollywood. And for each program, we'll call Judge Smith and say, can you lecture? Can you critique? Can you do this, do that? And the answer has always been yes. Special shout out, by the way, to Nora, of course, because Nora and her staff have been wonderful. The Litigation Academy could not function without them. And I could go on with other examples. The Hope Court, which is revolutionary, and under Judge Sullivan's stewardship, it's been just tremendously successful and made a real impact in the lives of hundreds of people. Judge Smith has taught a variety of classes here at the law school, as you know. We co-taught a course on federal practice with Mike Daly and with Jane Rinsberg for about 5 years, which is a very intensive course, but the whole idea was to try to demystify the federal process, the federal procedure for law students, so they wouldn't be afraid to come to federal court. Most of all, he opened his chambers to so many law students. I was called one day to come to his chambers for a mediation, and this was to be plaintiff, defendant, judge, very intimate setting. And indeed, we got there, and it was plaintiff, defendant, judge, and about 14 law students in a circle around the whole process. I can tell you today, thanks largely to Judge Smith, as well as Judges McConnell, Sullivan, Allman, McElroy, that our federal court today is far more transparent and far more a welcoming place. It is today a much, much better place in which to practice. And that's thanks largely to the efforts of Judge Smith. And I know there's many, many lawyers in Rhode Island who join me in wishing you many more happy years on the bench. We hope you're going nowhere. Thank you.
I think you're up, Judge.
Well, I think I've talked quite enough, actually. So no, I just want to say thank you to all of you for the opportunity to to have this career and to be involved with the law school for all these years, and for these very for this nice celebration and nice wonderful remarks. And I sort of feel a little bit lately like I've been attending my own awake or something. So I hope that's not a sign of anything, but you know, I really am not going anywhere anytime really soon anyway. So I just I'm just sort of filled with gratitude and a little embarrassed by all this, and but so I don't think I have much more to say in terms of words of wisdom, other than let's just all carry on and you know, keep doing what we've been doing, and hope that we get through the next few years unscathed. So again, thank you.